Let's talk about legal pathways to becoming a permanent resident in the United States and eventually becoming a U.S. citizen. Hi, I'm attorney Larissa Davis. I am an immigration lawyer in Jackson, Mississippi. I represent clients nationwide before immigration courts and before USCIS for different types of immigrant petitions and applications. So this is going to be a general overview. This is not legal advice. If you want to speak to an experienced attorney, you can call my office at the number below for a consultation. So there are various pathways, humanitarian, family, and business methods in which a person can begin processes before applying to become a permanent resident in the United States. I'm going to talk a little bit about each of these types of categories. Okay, humanitarian is the kind of case where a person comes to the United States maybe seeking asylum because they were persecuted in their home country and maybe they faced persecution for one of the qualifying reasons, such as political opinion, for their nationality, for their race, for their religion, or because of something called particular social group. So if they belong to a particular social group and they were persecuted for that reason, that is one of the 5 reasons or bases for applying for asylum. That is something that has to be proven for the person to be eligible to get asylum. Some asylum seekers present themselves at U.S. borders, so at a port of entry. Some asylum seekers cross into the United States at the border or other ways that are not lawful, but they could be paroled into the United States or even pursue their case for asylum within a detention center. Okay, other humanitarian type cases could be U visas, which are for victims of crime inside the United States, where a person cooperates with law enforcement and provides helpful information. Okay, another is a T visa. So this is for victims of human trafficking in the United States. Another could be VAWA application, which stands for a Violence Against Women Act claim, where somebody was suffering from domestic violence from a U.S. citizen, spouse, or parent, or child. So these are some examples. Some people also enter as refugees through the Office of Refugee Resettlement. That's a separate type of category. But these are some examples of humanitarian reasons or beginning pathways for a person to enter the United States and pursue lawful permanent residency. Each of these have different forms, required evidence, and they take a long time, especially when you're dealing with immigration courts right now. I recently had a client with a case scheduled for their first hearing in 2029. The date of this recording is June 2025, which means my client won't go before an immigration judge for 4 years. So that gives you an idea for people out there who don't realize how backlogged this system is. A lot of these other applications are not processed by immigration courts, but by U.S. Citizenship and Immigration Services, USCIS. These are affirmative applications filed with the immigration agency, and those have to be processed. There's evidence and interviews and a lot of other steps within each of these types of applications or petitions. Okay, family-based petitions. So these generally begin with the I-130 petition, and these are petitions for immediate relatives of U.S. citizens or lawful permanent residents. So it might be through marriage, it might be through a parent or a sibling, and these processes can also take a long time. For example, a marriage to a U.S. citizen petition could be taking 1.5 to 2 years right now. That's how long that's taking, and that's one of the shortest categories, whereas others take much longer. If you want to see more information about that, you can look at the U.S. Visa Bulletin, which is published every month by the Department of State, and you can see for other categories of family members how long it's taking, and especially for certain countries like Mexico, China, and the Philippines. And you can see, for example, siblings from Mexico who have a U.S. citizen that's petitioned for them. USCIS is just now in 2025 processing applications or petitions filed from 2001. So that means, just for an example, if you are a Mexican citizen and your sibling filed for you in the United States, you will be waiting all right, and then here's another one, business, so maybe EB-2 national interest waiver or EB-5 an investor visa, which requires a significant amount of investment. We're talking about over $1 million or $800,000 if it's in certain targeted employment areas, rural areas. So each of these have their own filing fees and criteria. You have to submit a lot of documents, records, and evidence. So let's say a person goes through one of these ways, humanitarian, family, or business. Each of these is going to take, at the minimum, a year or longer. One that I also left out, SIJS, a special immigrant juvenile status. This is for juveniles, minors, those under 21. They can't even adjust status to become a lawful permanent resident right now. Same with asylum seekers, meaning if a person has gone through the asylum process, proved their case, won, or were granted asylum in the United States, they can't move on to this because the current administration, Trump administration, has stopped that for certain people, or paused or frozen that for asylum seekers, SIJS, and for refugees. That's just one of many ways the administration has made it more difficult or impossible for people to actually be legal in the United States. Another problem is if a person is dealing with USCIS and has problems, there used to be something called the Ombudsman's Office, which could assist them with those problems. It's sort of like an oversight of the USCIS agency. Well, they got rid of that in this administration. Currently, to my knowledge, at this point in time, it is not operating as it usually was previously. So we'll see what happens with that. We'll see what happens with these being cut off for these types of humanitarian type of pathways. All right, so let's say someone goes through this process. By the way, this is a lot of work, a lot of time, a lot of effort, a lot of money. Even if someone tries to do it on their own without an attorney, which I do not recommend because it's more likely that you'll either get rejected or get a request for evidence, RFE. It could take longer. And certainly you can be ordered removed or deported if your case is in immigration court. So it's not worth the risk. After going through all of this, and let's just say it's 2 years or more that a person goes through one of these processes, they finally can go to the next step and they can apply to become a lawful permanent resident. They might have to go back to their home country to go through consular processing or adjust status. So they might be filing a I-485 form adjustment of status, which is currently $1,440 to file with the U.S. government. That's if they're in the United States and eligible to adjust within the country. If they're not eligible to adjust, they have to go through a process called consular processing. These are two separate processes. Again, a lot of fees, time, effort, money, and it depends on the circumstances for each case on whether they would do one or the other. All right, so after they go through all that, and let's say the person we'll just say adjustment of status. Let's say the person's in the U.S., they're eligible to adjust status, become a lawful permanent resident. They have to wait 5 years before they can become a U.S. citizen for many categories, except if they are married to a U.S. citizen. If the person is married to a U.S. citizen, they only have to wait 3 years before they apply to become a U.S. citizen. There are certain requirements, for example, filing an I-751, removal of conditions. If they have a 2-year green card, you might say, I don't know what that means. Of course, this can be complicated, and there's a certain man in Mississippi all over the news who's being deported because he didn't do this step. So there's various steps within this process that have to be followed. And then 1 year for those who honorably serve in the military, has to be honorable. They may be eligible to naturalize to become a U.S. citizen. And there's various applications depending on eligibility for becoming a U.S. citizen. So after going through one of these ways, then the person has to meet criteria to become a U.S. citizen and go through the testing process. There are some exceptions, but as you can see, it's a very long and complex system.